Socrates once said that when the debate or argument is lost, slander becomes the tool of the losers. Apparently, this is exactly what is happening in India. The opposition has been getting repeated setbacks in every manner possible, which have made them sore losers, and hence the irritating anti-democracy ranting is being amplified on any pretext possible. On the electoral front, the majority of voters are not buying the opposition's theory of victimhood, and institutions have refused to bow down in front of their false cry. These institutions have refused to offer any carry favors in their desperate urge to seek validation from this cynical bunch of losers. Now, in a massive humiliation for the opposition, the Supreme Court has virtually junked their rhetorical claims on the Agnipath scheme. Namaste and welcome to TFI Post. I'm your host Paurush Gupta. Let's begin. Recently, the Supreme Court upheld the validity of the Agnipath recruitment scheme. The court dismissed two petitions that had challenged the Delhi High Court verdict passed earlier in January this year. The two pleas had sought directions to complete the previous recruitment process for the Army and Air Force. Apparently, those recruitment drives were cancelled after the formal announcement of the Agnipath scheme in June 2022. The three-judge bench stated that the candidates who were previously chosen for the defense forces through recruitment procedures, including rallies and physical medical exams, do not have a vested right to appointment. The apex court opined that public interest outweighed their considerations. The three-judge bench was comprised of Chief Justice of India D.Y. Chandrachud, Justice P.S. Narasimhan and Justice Pardiwala. The bench said, and I quote, "Sorry, we would not like to interfere with the High Court verdict. The High Court verdict had dealt with all the aspects," unquote. The bench also rejected the argument that the doctrine of promissory estoppel will apply in this case. It stated that the decision to not proceed with the previous recruitment process could not be termed arbitrary. The bench gave the rationale that promissory estoppel will not apply when larger public interests are involved. CJI Chandrachud stated that there is nothing for them to interfere with that, and that is a matter of public employment, not a contract. Petitioner's counsel Arunava Mukherjee clarified before the bench that he is not challenging the Agnipath scheme per se, but rather the matter is limited to the completion of the previously notified recruitment procedures for Army and Air Force. He argued that the central government postponed the exams multiple times, citing the COVID pandemic. However, in June, this was all of a sudden replaced by the Agnipath scheme. He added that the Air Force exams were held, but only the results were not published. Going further, he highlighted the fact that the union government had only postponed the exams and they were never cancelled. Responding to this argument, CJI Chandrachud observed that there was no vested interest on the part of the government in doing so. CJI said, and I quote, "So, the process that began earlier, physical and medical tests happened, but the entrance test did not happen. And when the new scheme came, they decided not to go ahead with it at all. But there is no vested right ultimately." The council urged the bench that the Agnipath scheme would not be affected even if the students were inducted. However, the Union Government's Counsel Additional Solicitor General Aishwarya Bhati apprised the bench that the Delhi High Court's judgment has already dealt with these issues in detail. ASG added that the process was not pick and choose. The government had to fill the vacancies in the interest of defense and national interest. The bench also dismissed the second plea that was filed by Advocate ML Sharma. Mr. Sharma's main argument was that the scheme could not have been introduced through an executive order and there had to be a parliamentary law on this. But these two petitions were dismissed by the three-judge bench. In addition to these two petitions, Supreme Court Advocate Prashant Bhushan argued in favor of the third petition. He argued that the doctrine of promissory estoppel will apply in this case. To which CJI replied, and I said, "Frankly, Mr. Bhushan, there is no vested right here. It's not arbitrary in the circumstances." However, at the earnest request of Mr. Bhushan, the bench agreed to consider his plea separately on April 17th. The Supreme Court bench has also asked the centre to file its response to the third plea, which pertains to recruitment in the IAF. Earlier on February 27th, the Delhi High Court said that the Agnipath scheme was formulated in the national interest. The court had added that it had laudable objective of maintaining national security. After his retirement, former CJI Ranjan Gogoi revealed before media houses that there is a certain lobby that puts undue pressure on the judiciary to give a verdict in their favor. Otherwise, they do everything possible to tarnish the reputation of the judiciary, including the apex court. Back then, he had said, and I quote, "Independence of the judiciary means breaking of the stranglehold of a few dozen people over it. Unless this stranglehold is broken, the judiciary cannot be independent. They hold judges to ransom. If a case is not decided in a particular way advocated by them, they malign the judge in every way possible. I fear for the status quo judges who do not want to take them on and who want to retire peacefully." Unquote. The same has been observed time and again. for making unfounded, baseless, manufactured narratives and falsehoods, the opposition has been getting a tight slap from the judiciary. So far, they have been humiliated in the Rafale Pegasus demonetization 2002 case against then Gujarat CM Narendra Modi, Ram Temple, or the recent Agnipath recruitment scheme. Now, on account of their own incompetence and inability to corner the incumbent Modi government on genuine issues like farmer distress, skill gap between the new pass-outs and the market demand, among others, they will increase their rhetoric of the death of democracy. In the upcoming time, especially in the election near, these voices will keep repeating these cliche and rhetorical charge on loop, some of which are as follows. Democracy is backsliding in India. India is now an electoral autocracy. The West should intervene in India. Soros is the last savior of human rights in India. EVMs are hacked and unannounced emergency has been imposed. Opposition voices are being trampled. The media and key officials of the premier institutions have been compromised. Institutions have been compromised. There will be no elections in the future if they don't come back to power, and so on. However, no matter how desperately they try to present Indian democracies in a bad light, the matter of fact is that these independent democratic institutions will judge matters on their merit. And from time to time, they have been issuing stern messages to both opposition and the ruling dispensation. However, if opposition still finds loopholes, which are possible in a gigantic system, especially present in India, they can galvanize the voters, the real power of any democracy, in their favor and fix these loopholes. But for that, they have to drop cynical opposition, victim mindset and anti-democratic ranting, as it will do them no good. They should stop whining and acting like sore losers and get some rationale and logic behind their constructive criticism of policies and issues rather than blindly judging things in black and white and projecting themselves as the only true successors to power.